Hi, I'm Jay from Personal Bar Prep, and this is Simplified, our series designed to simplify tough subjects on the California bar exam. Today, I'm going to simplify the Dormant Commerce Clause. As you know, the Constitution grants Congress the power to regulate interstate commerce, and it stands to reason that if Congress has the power to regulate interstate commerce, that the states likely have no power to regulate interstate commerce. And that happens to be the case. And the law for that is made up by the court. It's called the Dormant Commerce Clause. And the Dormant Commerce Clause tells us that where Congress is silent with respect to an issue in interstate commerce, then the states may regulate interstate commerce so long as they do not unduly burden interstate commerce. So, any state regulation that affects commerce raises a Dormant Commerce Clause problem. Now, the analysis goes like this. The state law may not unduly burden interstate commerce. The undue burden test is always a balancing test. And in this case, what we're balancing is the important state interest against the incidental effects on interstate commerce. And if the effects on interstate commerce are greater than the benefits to the state, then the law will be considered unconstitutional as a violation of the Dormant Commerce Clause. Now, there is a wrinkle we have to add. There are some laws that are what we call discriminatory in interstate commerce. What we mean by that is the law is designed to benefit in-state economic interests at the expense of out-of-state economic interests. Where you have such economic protectionism, we have a discrimination problem under the Dormant Commerce Clause. Where we find a law is discriminatory in interstate commerce, we use a different test. Now the test is we look at the important non-economic interests of the state promulgating the regulation, and we ask ourselves, are these important interests, and if so, is this the least restrictive or the least discriminatory means by which to achieve this state interest? If the answer to that is no, it will be a violation of the Dormant Commerce Clause and thereby unconstitutional. Now, the state may argue that they are not subject to this limitation in the Dormant Commerce Clause if the state is acting as a market participant. The market participant exception applies only to discrimination in interstate commerce. And what we ask ourselves is this: if the state is acting as a market participant, meaning a buyer or seller in the marketplace, it is not bound by the rules of the Dormant Commerce Clause, because it is not acting as a government, it's rather acting as a buyer or seller. Now the question is, how do we determine whether or not a state is a market participant? It's not a simple analysis, but here's what you want to look for. Look for the downstream effects of what the state is doing. What will be the long-term impact of the state's action? And if that impact appears to be regulatory in nature, then the state is not acting as a market participant, rather it's acting as a government. For example, there is an essay where there is a state that prevents the transportation and dumping of trash from out of state into a particular city's landfill. The city runs and operates the landfill. The city is clearly discriminating by preventing the waste from out of state from being dumped in that landfill, but allowing it from inside the state. There's clearly discrimination. The city claims, no, we're a market participant. We are selling space in a landfill like a business. But to determine if they're a market participant, we must look at the downstream effects of what they're doing. And the facts tell us it's a new landfill with a lot of unused space. And the only reason that they're limiting it is to preserve the space. Well, that is a form of regulation. That is not what a business would do. Therefore, that city cannot hide behind the market participant exception. And as a result, that discrimination would be unduly burdensome to interstate commerce, and as a result would violate the Dormant Commerce Clause. So remember, here's what we're looking for. Some government conduct by a state or a city or a county, not the federal government, that regulates interstate commerce. If it doesn't discriminate in interstate commerce, it will be constitutional so long as the state's important interests are greater than the incidental effects on interstate commerce. If not, it's unconstitutional. If it is discriminatory in interstate commerce, it is per se unconstitutional unless you have an important state non-economic interest, and this is the only way to achieve it. In other words, there's no less discriminatory way to achieve it. The only way around it is to show that the state is a market participant, which means they're acting as a buyer or seller rather than a regulator. That's the Dormant Commerce Clause. If you enjoyed this video and found it helpful, leave a like or share it with others. If you have questions about the topic, leave a comment. Personal Bar Prep is the small group California Bar Prep company. If you like the video, you're going to love our course. The link to our website is in the description below. Thanks for watching.